I'm Richard Katskee. I'm the legal director at Americans United for Separation of Church and State. I also teach law and religion at the American University Washington College of Law, but principally what I am is a litigator. I try cases and argue cases on the issues that we're talking about today. So I'm going to give you a little bit of that perspective. But first, I do want to say thank you so much for having me today. I think that this is going to be a really interesting mix of thoughts and ideas and topics, and I'm so pleased to be a part of this great conference that I hope you all will enjoy as well. I want to talk this morning about what I think is the set of issues most in the news. Oh, this seems to be syncing. I think it's me. The issue that is probably most in the news when it comes to questions about religious exemptions. And their demands, and Fred touched on this already, demands for exemptions from anti-discrimination laws so that you can refuse service to same-sex couples. Now, traditionally, religious accommodation claims arise when when some law just happens to make it more difficult for me to practice my faith. The law is no alcohol to minors, and someone says, but what about those of us who use wine as a sacrament? Their claim is essentially, we aren't hurting anybody, just leave us alone to practice our faith. And they end up receiving a legal exemption that allows them to serve communion wine or kiddush wine to the kids. The claims that I'm talking about today are of a different character. When people demand an exemption from an anti-discrimination law, they're asking for a special right to discriminate. They're saying, often expressly, I view you as a sinner, and so the law has to allow me to treat you differently from everybody else, worse than everybody else, so that I'm not condoning the sin. Or even, I deserve the legal right to try to have you live in accordance with my religious beliefs. We have public employees who try to do that, and Fred mentioned Kim Davis, who is the clerk at the clerk in Rowan County, who refused to issue marriage licenses to same-sex couples. After the Supreme Court recognized the constitutional right to marry, Davis argued that God's law trumps the decision of the Supreme Court, and in her view, God's law is that she can't be complicit in same-sex marriages or marriages of same-sex couples by allowing the county clerk's office to issue the licenses. Now, the legal rule on this is actually quite clear. Here's my favorite scholarly statement of it for its conciseness and specificity. Public officials are not free to apply personal convictions, religious or other, in place of the defined responsibilities of their public offices. Here's how that works. The government can't discriminate. When government employees are performing their jobs, they are the government. They're not acting as private citizens, so they can't discriminate. They can't say, I don't like your kind, so for whatever reason, so the county won't serve you. But that brings us to the question of private businesses that argue that they shouldn't have to serve same-sex couples because they shouldn't be forced to condone or facilitate the sin. And they're not the government, obviously. Now, where there are laws that require equal treatment, they want a religious exemption to decline service. And so let me talk you through a case. As I said, I'm a litigator. This tends to be the way that I think about things. So in a small town in Washington State, Robert Ingersoll and Kurt Freed decided to get married. They had been patronizing their local flower shop, Arlene's Flowers, for about 9 years. The owner, her name is Baronelle Stutzman, knew that they're gay, and it seemed like no problem. But when they went to order flowers for their wedding, Stutzman turned them away, refused to serve them, because she said she views it as sinful for two men to marry, and she wouldn't be in the business of supporting that. In fact, she went further than that, though, and she said that no business should serve couples like Robert and Kurt. And especially in a small town like the one where they live, finding alternative providers is not so easy. It may actually not even be possible. So the state of Washington acted to enforce what's called its public accommodations laws against the flower shop. Those laws say that if you run a business open to the public, you can't discriminate in who you serve. The shop fought back quite hard in both court and the media. As a result, Robert and Kurt got harassed and received many, many death threats. So many that while they did ultimately get married, they gave up on their dream of a big wedding surrounded by family and friends, and instead, and of course flowers and cake and all the other things that people often have at their weddings, and instead just had the two of them and their officiant in their home, really no celebration at all, because they were scared and were right to be. Now, in the court case challenging the enforcement of the public accommodations law, which results in a small fine, the flower shop argued that it has a constitutional right to an exemption from the public accommodations laws based on the owner's religious objection to two men marrying. Although that's a claim premised on a religious view, it turns out that it doesn't principally get made under the First Amendment's free exercise clause. Here's why. The Supreme Court has held that if a law is neutral with respect to religion, that means it doesn't single out religion or any particular faith for disfavor, and it's generally applicable to everybody. The fact that it incidentally burdens some people more than others because of their faith doesn't give a legal claim. The Supreme Court has also recognized, and Gene is going to take issue with what I say now, and I know that's what his talk is going to be about, but the Supreme Court has also recognized that my right to exercise my faith freely doesn't come with the right to impose the costs and burdens and harms from my religious exercise on other people. Under those legal principles, Arlene's Flowers doesn't have a free exercise right to violate the anti-discrimination laws because those laws weren't written to disfavor the flower shops or the florist's faith, and because refusing to serve you because I don't like your kind is a substantial harm. It's the harm of being told, you aren't as good as the rest of us, so the law has to specifically allow me to treat you differently or worse than everybody else. Now, because the free exercise clause doesn't provide much help to the flower shop, rather, the flower shop repackaged its claims for religious exemption this way. Arranging flowers is our artistic expression. It's our protected free speech. The state can't compel us to speak in ways that favor or promote the sin of two men marrying, so it can't make us do our art for them. That's the legal claim as a free speech claim. The shop did concede that, okay, maybe if you sell toasters or something, you have to provide those to everybody. Maybe if Robert and Kurt had wanted a crate of loose flowers, we would have to sell them those. But the state can't make us arrange the flowers because that's our First Amendment protected expression. Now, in February, the Washington Supreme Court ruled against the flower shop, choosing that when you choose to sell to the public, you have to obey the law. When a couple buys flowers from you, the court also explained, you aren't being forced to say that you favor their marriage. You're just being told to provide goods on an equal basis to all comers. There's a case in Colorado that came out of Colorado in which a bakery made the exact same argument about artistic expression about baking. And the case came out the same way. In that case, I represented a different bakery in Colorado that also makes wedding cakes. And what my client explained is this. She said, yes, of course there's artistry in making wedding cakes. We work really, really hard to make something that's beautiful and delicious. But nobody thinks that because I sell you a cake, I'm putting my stamp of approval on your marriage. Nobody thinks that I'm saying, I've looked into your relationship and figured out that it really is a match made in heaven as opposed to someplace else. Your wedding, your cake, your message to your guests. So back to Washington. In rejecting the flower shop's argument that if you do something artistic, you have a free speech right to violate public accommodations law, anti-discrimination laws, the court recognized that the flower shop's argument is the same one that was made about marriage in a slightly different context about half a century ago. It was this. Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for interracial marriages. The fact that he separated the races shows that he did not intend for the races to mix. That was the basis in Loving against Virginia in 1967 to convict a couple under a state statute banning interracial marriages. Now, in that case, the Supreme Court had no difficulty striking down the law, concluding that there was patently no legitimate overriding purpose for it, even though what the law did, and all that the law was doing, was to embody and enforce what were the widely held religious beliefs of the day. The law shouldn't license and enforce discrimination, whether that's on religious grounds or otherwise. Now, another thing to note from the flower shop case was actually something that we argued in an amicus brief that we filed to the court. We pointed out that just like florists and bakers, it turns out that nice restaurants and barbers and nail salons and all sorts of other businesses use artistry in producing what they sell. If that gets you an exemption from the anti-discrimination laws, then most businesses could bar their doors to pretty much anyone they please. Interracial couples won't serve them. Interfaith couples, nope. Women, people with disabilities, not them either. We don't like them. We can shut the doors on them. Quoting our brief, which I was frankly pretty proud of, the court said this: the flower shop's preferred rule would create a two-tiered system that carves out an enormous hole from public accommodations laws. Under that system, a dime store lunch counter would be required to serve interracial couples, but an upscale bistro could turn them away. Real religious freedom, as it is recognized in our law, means that we each have the right to believe or not, to worship or not, as we choose. So if you believe that same-sex relationships are a sin, fine. You don't have to be in one. You don't have to invite people who are in one over to your house for dinner. The legal question here, though, is should we have the legal right to use the law to tell others to live how we think that God or the Bible says that they should? Now, the answer to that question has historically been no. Religious freedom is a shield and not a sword. It protects me. I don't get to use it against you. I don't get to violate your religious freedom or your other basic rights in the name of my religion. That's the rule. That's the constitutional rule that has allowed us as a nation to live together in relative harmony despite profound diversity and disagreement on matters of religion and belief. So here's the commercial. When people advocate for the rights of Arlene's Flowers or Kim Davis to discriminate, they're threatening this critical constitutional protection. Last thought that goes with that is this. So, wait a minute. There we go. Sandra Day O'Connor was appointed to the Supreme Court by Ronald Reagan in 1981, and she served for 2.5 decades on the court before retiring. During that time, she wrestled with the proper relationship between religion and government in case after case. As often as not, I disagreed with her conclusions. But here's what she said in her last church-state case on the court with 25 years of hindsight. At a time when we see around the world the violent consequences of the assumption of religious authority on government, Americans may count themselves fortunate. Our regard for constitutional boundaries has protected us from similar travails while allowing private religious exercise to flourish. Those who would renegotiate the boundaries between church and state must therefore answer a difficult question. Why would we trade a system that has served us so well for one that has served others so poorly? That's the question that I think is posed when we start talking about religious exemptions from the law that harm and burden other people. And that's the thought that I want to leave you with. Thank you.